let us at this stage simply say the record of the decision plays a very important role. And in fact, I must also say upfront that all the decisions that one has in review matters, all of them, and I've looked at well, we mentioned a number of them, but there is not even a single decision on record, whether in the SCA Constitutional Court or even in the High Court, that says that in review proceedings, you must use Rule 35. The record of the proceedings referenced in all these matters, it's a record in terms of Rule 53. And the reasoning is very obvious. And perhaps I must do so by reference to Jockey Club. We try to analyze why Jockey Club does not assist the SIU. But the principle that is established in Jockey Club, before we deal with whether the applicant brings, whether the SIU as the applicant is entitled to rely on Jockey Club, what the court says, what the SCA says is that very often a litigant brings review proceedings against a decision maker. That litigant is a private person, does not know what happened behind the scenes. In fact, in the Lawyers for Human Rights case that we reference, it's at page 006-5, -5, 0006-5. Then Judge Van der Bijl at paragraph 23, he says that decisions of this nature are taken behind closed doors. So you, as a private citizen, you wouldn't know what was discussed by the decision maker, what was considered by the decision maker. You wouldn't know. And that is why you cannot use rules like Rule 35. And the onus cannot be on you to request documents. A party that has taken a decision must be upfront and say, look, I've taken this decision, you are taking it. Here is a record of the proceedings and the reasons. Now, the reason why here it is different, and before I go further with Jockey Club, just to make 2 points. The record, it is not only for us as LNG. It is also for the court. The court dealing with a review. It must be placed, and we give reference to paragraph 12 of our heads. We give reference to that DA versus acting NDPP case. We quote what that decision says at paragraph 12. Let me just read that into the record, because this is important. Without the record, a court cannot perform its constitutionality entranced review function, with the result that a litigant's rights in terms of Section 34 of the Constitution to have a justiciable dispute decided in a fair public hearing before a court, with all the issues being ventilated. So before we even get to our rights, our courts have said, and I emphasize here about the record. This court is referring to a record not discovered. So the court is unable in a review application to properly consider the issues as required in terms of Section 34 of the Constitution. So that is the first issue. For the benefit of the review court, the court needs to know. But secondly, of course, is for the benefit of the respondents. The applicant, where the applicant is a private person reviewing a decision of a state organ or another quasi-judicial decision. In this case, as I will show, the respondent is almost in the position of the applicant, where a review deals with is of a review against a state organ. We're almost in that position.
Which authority are you relying on, which advances the respondent's position in relation to this principle? Because most of the authorities you rely on actually advance the case of an applicant.
But that is a mistake that...
No,
that
just answer my question. Is there authority that...
The Stanton case, I will get there. I will get there. But let me advance as an issue of principle. One must not be bogged down on whether it's the applicant or whether is the respondent. One must consider the applicant in this particular case. What type of an applicant is it? We must bear in mind that these self-reviews have not been a norm for many years. These are mainly new occurrences, and that is why there might be new terrain in law to deal with. But we must not be bogged down on applicant, on respondent. Let's look at a private citizen. And here we're dealing with LNG is a private citizen. It is expected to come to court.
I think you can argue that, Mr. Mutepe, you can argue that. I've asked you a very simple question. Is this a novel issue, or is there an authority you rely on that advances the position of a respondent? It's a very important consideration, especially because it seems that you are approaching this as a novel issue.
Yes.
Yes.
No, indeed. No, it's a novel issue, but there has not been an authority decided on this issue. And like I say, because self-reviews are fairly new. They're fairly new, so it's no surprise that we have an issue of this nature being argued here for the first time. But my argument, and let me, so that I don't lose my train of thought, I've already made the point that it is for the benefit of the court that we have the record, but secondly, benefit of the LNG in this case. The benefit of LNG, if LNG was an applicant bringing a review, obviously it would have been entitled to that. I don't think the SIU will even dispute that.
Yes.
But in this case, we're in the same position as in Stanton Rush case. Because there the SCA said, SAFA brought a review application against the register. SAFA was happy that it does not need the record. It knew what its case was, just like it was the case in Jockey Club. SAFA was the applicant. It knew what its case was. It knew all the legal arguments it needed to advance. It did not need the record. It did not need the reasons. But what the SCA says in that, and that is distinguishing Jockey Club, to say, look, even if SAFA as the applicant did not need the record, the respondent here, the second respondent was Stanton Rush. Second respondent is a private citizen, does not know also the happenings behind the door when the decision was taken. The second respondent was entitled to the record. We deal with that case at paragraph 26 of our heads. So there the SCA says, yes, in terms of Jockey Club, you may, and it's important what the court says. We quote that because we made the point that generally a person who brings a review application must do so in terms of Rule 53. And the SIU, of course, they say, no, but that's not a general approach. But if one reads what is quoted there, the first sentence, since the present proceedings are primarily review proceedings, SAFA should have utilized the provisions of Uniform Rule 53. That's what the SCA says. It says SAFA chose not to do so. But following Rule 6 instead of Rule 53 is not necessarily irregular. It finds that. But it says an applicant is, however, not entitled by electing to disregard the provisions of the rule. Again, the rule, we're talking 53, to impinge upon the procedural rights of a respondent. In this case, the respondent, we say, LNG is a respondent. The applicant, being the SIU, is not entitled to infringe upon our rights to the record. So this is we say, and by analogy, it is applicable to this case. Yes, and I've made a point based on the question raised by our ladyship that is there authority that says in this case where SIU is the applicant, that we should still get the record. There is no direct authority in facts of this particular case, but this is the closest that we get to. And it says the other respondent who's not the state organ is entitled to that to the record. It says, in fact, over the page, that's what this court says. Stanton was entitled to have the full record before the court and have to have the registrar's reasons for the impugned decisions available. As a respondent in an ordinary application, it does not have those rights. That's what the court says. So we say the SIU is impinging on our rights by not giving the records. And I want to show your ladyship why we say Rule 35 is not appropriate. Firstly, the Constitutional Court has made that distinction. To say with Rule 35, it's about the pleadings. It's about the pleadings. And I know now they have belatedly tendered in their affidavit, but even the tender does not go far enough. In Rule 35, the pleadings have been filed, or in an affidavit sense, there is reference to a particular document that I do not have. And I say to the applicant that you are making reference to this document. In terms of Rule 35.14, please give me a copy of that. So with Rule 35, it is targeted, and it is only to documents that will be relevant as defined by the pleadings. That's what the Constitutional Court says also. But that's not what we're dealing with here. Here, the record, and the honor should not be on us to say what documents. Because as I've indicated in the Laws for Human Rights case, the court says, you don't know, as a private citizen, you don't know what the decision maker took into account. All this were taken behind closed doors. So what documents are you going to request? Here, in fact, what we have the SIU telling us that follow Rule 35. If you're not happy, you can come back again. You tell us the very same Rule 35 and ask for more documents. But that's wrong. That is not how review application should be dealt with. The record must be given up front. And what concerns us most, the SIU itself says so in paragraph 22 of their affidavit as 005-26. If I may just read that, because they say we must request in terms of Rule 35. And then they say, in any event, many of the relevant documents, and in brackets, they say, and all of those which the SIU and MEC consider necessary for the proper adjudication of the main proceedings have already been provided to LNG as part of the funding papers in the main proceedings. So they are saying we must believe what they tell us, that they've given us almost everything. Well, they say all those which they consider necessary for the adjudication, but it is not what the SIU considers necessary. It is not them who must tell us what is necessary, what is not. And that is a danger with employing Rule 35. They may come back to us and say, but we don't have that document. We don't know. There are legal consequences that follow when one refuses to give a document in terms of Rule 35 and where one refuses to give document in terms of Rule 53. In terms of Rule 35, the only consequence is that you will not be allowed to rely on that document if you refuse to grant it. But Rule 53 is different. If you have the record, you refuse to grant it, the opposing party may even argue that just on that basis, if you are the respondent, your defense must be struck out. And in this case, if you are the applicant, that your case must be dismissed because you are hiding documents that should be there, that you do have. Even where you did not, in fact, with Rule 53, even where you give reasons, but then when you file your affidavit, you give different reasons. Even that, authorities say that the court can in fact strike out your defense and strike out those new reasons in the affidavit. So there are different consequences that follow from employing Rule 35 as opposed to employing Rule 53. But I want to go to the Chauke decision because this is a mainstay of the applicants of SIU's case. And of course, we say in relation to that case, number one, the judge ultimately ordered the release of the record, not simply Rule 35 documents, but the record. It ordered that. But we say, insofar as that judgment suggests that Rule 35 is appropriate for review, again, we say that the judgment is incorrect. It was wrongly decided. And we say it was delivered in January 2018, whereas the HSF of the Constitutional Court that we rely on was delivered about 3-4 months later. If one considers what what the Constitutional Court says, that Rule 35 is for where the pleadings are defined and where the document is relevant, it is quite clear that it's not appropriate here. But there's a further reason why that judgment is not in support of the SIU's contention. In that judgment, the SIU, in fact, what is not telling this court, the SIU expressly disavowed reliance on any review. It said to the court, we are not bringing this as a review application. We are bringing this on the principles of contract. That's what the SIU tells the court. And that, my lady, you find in case lines, on case lines 007-133. -133 at paragraph 8. If I may just read the last sentence. The Tribunal just says the SIU contends that it does not seek to review any particular decision and that this claim is one based on the principles of contract law. It further contends that since its response to Marepo's proceeding, Rule 35.12 notice, no further documents need to be called for in terms of Rule 53. But that was the SIU's case. It expressly told the court that this is not a review application. That is why we're coming in terms of Rule 35. I'm surprised in this case where they say this is a review application. They still want to rely on this case. Of course, the judge in that case went on to find that, yes, even if you say you are not bringing a review, but this is in substance, a review is tantamount to a review. But even in that case, my lady, even where the SIU was saying they're not relying on review, the judge says at paragraph 23, to simply make an order in terms of Rule 35.13 in the fashion mentioned above could conceivably open the door to extensive further interlocutory proceedings and extended or possibly even protracted discovery procedures. In the very same case where the SIU says, but this is not review, the judge says still, even if I simply do it in terms of Rule 35, we are going to have a protracted litigation. And it's exactly what the SIU is suggesting to us. It says expressly, request in terms of Rule 35. If you're not satisfied, again, request in terms of Rule 35. Now, we know that in that case, what the judge ultimately ruled is that the department must produce the record of the proceedings. But I want to refer Manel Jr. when he was uploading the cases, he inadvertently also uploaded the final judgment in that case, because what we see in the case I've just referred to was an interlocutory application. So the matter proceeded to deal with the main issues. In 2020, the judgment was delivered. That judgment is your ladyship will find at 008-230. 008-230. That's where it starts. But what I want to emphasize, and I'll refer to just a paragraph or two. When it went to the full court, the SIU again expressly made its position clear that it's proceeding on contract, not review. And the general judge goes on to analyze that, but you cannot simply say the complaint was that, whereas the contract price was X, the service providers ultimately had their prices increase over time to astronomical figures. And the SIU was saying, but that is wrong. And those extensions or the prices must be set aside or declared void ab initio. And the learned judge says, but you can't do that. You ought to have impugned the decision to award the contract, one, or the decision to extend the contract, because that's an administrative decision, a decision to extend that contract. But you did not do that. You come here in terms of contract. At paragraph, and then judge analyze the applicable principles. I need not take your leadership through that. But at paragraph 46, the last sentence, after analyzing that, the learner just says, the SIU, however, did not seek to review and set aside those decisions in terms of legality review. So the learner just said, firstly, you could not have brought them in terms of, you had to bring a review, but not in terms of Baja, but as the Constitutional Court has said in Gijima, Tasima, and others, in terms of legality review, you ought to have brought this. But it says, but you did not do so. You did not bring your application as a legality. And as a result, it dismissed the SIU's application to say in our contract law, what you're asking for does not exist. You ought to have brought a review. So that which is being relied upon by the SIU, in fact, it does not support their case, that this case said in a review application you can bring a Rule 35. It does not support the case. So, my lady, we are firm in our contention that we've got to be given the record, whether the SIU chooses to use Rule 36, read with Rule 10, or whatever it seeks to use. We don't quibble with that. But no, because as we said in the funding affidavit, it is improbable, even if, and I know the SIU says yes, but there was no competitive bidding, so that's why there will not be documents. That's what they say. In our funding affidavit, we say, but it is improbable that one individual can, because in tenders, whether you're going to follow competitive bidding or it's going to be deviation, there's got to be a need analysis of some sort, where you say we're going to need PPEs, as in this case. We're going to need so many sanitizers because of this. It can be one person, the CFO, firstly deciding that, and then deciding that, okay, these are the type of PPEs that we're going to need. Thereafter, communicating with each and every one of the tenderers, or on her own issuing tender invitations, whatever they may have issued, whether it's by email, whether it's it's improbable that only one person. And what do we say,
Mr. Motepe?
Yes,
that is exactly the SIU case. If you look at the founding affidavit, that is exactly their case. They are not saying there was a normal bidding process. They are saying their case is Ms. Lithuania singularly awarded this tender. And that allegation is supported by, no, first of all, the investigator tells us that Ms. Lithuania no longer works for the department and she's not cooperating with the investigation. So where are you going to get your reasons from, right? And then Malotana, the COO, we are told that you have put up an affidavit by Lithuania in another matter, where she outlines in generic terms the procurement process in place during COVID in the department. But Malotana, the investigator here tells us that according to Malotana, the BAC was completely sidelined. And then there is another key individual, Pino, who we are told is not cooperating with the investigation. So all what the SIU has done here, it has obtained documents from the department. We are told that by the investigator and the founding affidavit. It also relies on a questionnaire, a response to a questionnaire by your client. So this is not This is not a normal review process that follows a normal procurement process. So we are here simply because your client takes the view that the version that Lithuania singularly awarded this tender is improbable. That's why we are here.
Now, Majari, let me explain what our issue is. We've heard what the SIU says, that they don't have documents. In our heads, we analyze what is it that one can distill from her affidavit. And you see, it is concerning that they would say that when it is the SIU that was involved in the case in which she filed an affidavit, where she clearly refers to documents and she attaches them, and which indicate what happened before. Remember the mere fact that there was no competitive bidding in a sense of BEC, BAC, it's neither here nor there. You may have a deviation, and here we're dealing with a deviation.
But we are told here it wasn't approved. That's dealt with in the founding affidavit.
No, I see that. They say
there's some draft document that was not signed, it wasn't approved.
It was not signed. That's what they say. But it's taking shortcuts. Before a decision is taken, all the preceding, for example, and I've indicated needs analysis. We're told that there was a war room. We're told that there was this lady was a chairperson of the BAC. We're told that there are all those things. We don't have.
The SIU version here is that the BAC was sidelined.
But my lady, we have attached her affidavit in which she indicates that there are indeed documents. And those documents, surprisingly, they are attached in another application. Even if the SIU did not have them, it now knows that they do exist. But we will not accept the SIU's version that they with their powers, they are unable to get into computers or get emails that led ultimately, and I'm talking before the decision is taken, all that information, that's what constitutes review record. We cannot accept simply them telling us an individual simply took this decision without, as we indicate, need analysis to say, yes, let's go procure this so many sanitizers, let's go procure so many masks. That is improbable. But in any event, what the SIU has said, and we need to go with what they say. They say many of the relevant documents have been provided. One, they say many, all the documents that the SIU considers to be relevant have been provided. That's not our inquiry. We say they must give us all the documents that preceded this decision. If they say, you know what surprises my lady, and also taking the question that your lady has asked, what are they tendering to give them in this Rule 35? Because they've now tendered to give everything, as we understand. What are they tendering to give? If the leadership is correct, that they have nothing.
No, I'm not saying they have nothing. I'm saying they have said they've crafted their case in the founding affidavit, and yes, that's the case they're going to have to stand or fall by.
And that we've read, that we understand.
And but they have attached documents on which they rely.
Yes, my lady, but your leadership seems to suggest that if they say that, then we must simply accept that. We cannot do that. And that's why I'm asking, if that is what they say, and if this tribunal is going to accept that, what are they tendering? What is it that they're tendering? Because if we are to believe them, then they have nothing. So we do not believe that they don't have the record. They certainly have the record. And the affidavit that we attach in the reply of Ms. Litton suggests that there are other documents. We're not talking BEC report here.
That affidavit is actually referenced in the SIU founding affidavit in the review, is it not? It is. The investigator says, I've had regard to an affidavit that narrates procurement processes in the general sense in another matter. So it's quite clear that in relation to this matter, the information that he is relying on, is that attached in the founding affidavit?
Then why do we not have the documents that she refers to in that affidavit? Why is the SIU not giving us those documents as part of the record? The fact that she relates in general terms how procurement works is irrelevant for the purpose of this discussion. All that we say, and in our heads, we detail what documents we say exist from her affidavit. If they've read that, they know what it says, why don't you simply give us those documents? At paragraph 36 of our heads, we detail that from here, it's clear, and we give even dates. In fact, I've asked Manele Jr. because I see the mistake that we didn't do in paragraph 36. It's about 12 items that we say can be distilled from her affidavit. What we didn't do is to give specific references in affidavit. I've asked Manele Jr. to upload a document with all those paragraphs, but with references. Now, I must emphasize this very strongly. And I hear what the leadership says is that it is their case that they don't have more. I hear what the leadership says.
No. It's their case that they are relying on the documents attached. I didn't say they don't have more. They are relying on the documents attached. It's quite clear from their founding affidavit.
What the leadership said was that they are saying the BAC was sidelined.
Yes.
It's only the CFO that well, let's say acted alone. And we say we dispute that. The affidavit attached here shows that there are other documents. The issue here is not only about the specific document, specific decision on the day. It's not only about that. It's about the events that precede the taking of that decision. All those events are necessary. From the time that a need was established to procure this, from that time onwards, and she says in her affidavit there are other SCM officials who would call service providers and so forth. We don't have all that documents, but we strongly urge your leadership. We strongly urge your leadership that the SIU must be ordered to provide the record of the proceedings, the record of the decision. If the SIU, well, they've tendered something, we don't know, we'll see. If they say they don't have anything, of course, we will then see what recourse we take. Whatever they give us, it may assist us to draft an answering affidavit. It may not, we don't know. But they must not be allowed to hide behind Rule 35. If they don't have, they will say so under oath they don't have. But they must be ordered to give the record of the proceedings. All the authorities that we see dealing with reviews, they talk about records of the proceedings. And that is our case. My lady, I believe those are our submissions, but we must emphasize and perhaps in closing what the court said in 10 Bull versus Jackson Hibiscus Coast Municipality. We reference that at paragraph 15 of our heads. And again, I must just read this into the record because these things are important as a matter of principle. The court there says undeniably a Rule 53 record is an invaluable tool in the review process. Let's emphasize that. It's an invaluable tool in the review process. It may help shed light on what happened and why. Give the lie to unfounded ex post facto after the fact justification of the decision under review. In the substantiation of as yet not fully substantiated grounds of review, in giving support to the decision maker's stance, and in the performance of the review court's function. If the SIU, for example, is misleading the court as to what happened, and I'm not saying they are, I must be understood, or if they have misstated some of the facts, we wouldn't know. If they make certain allegations that if one considers the record, that allegation is not correct. We wouldn't know as we stand here. And that is why this court says a record helps to establish if, for example, it says shed light on what happened and why, give the liar to unfounded ex post facto justification of the decision under review. And that is why we insist that we ought to be granted this record, not simply because the SIU is giving a tender, it believes it somehow doing us a favor. It is we require this as a matter of right. We'll be unable to exercise our right without this. So those are our submissions. And given this, on the issue of costs, we contend that the SIU must pay the costs of this application on a punitive court scale. When we requested the record, in fact, we're not even saying in terms of, we simply said, we noticed that you have not given us the record. Please give us the record so that we can file our ways. What was the response? The response was no. You can't ask for the record. You've got to go through Rule 35. That is what they say in the letter. We attach that as an extra TL2. That's what they say. So they did not. They don't say. Here are the documents like now they do in the affidavit. They don't say we tender this in terms of Rule 35. No, they don't say. It's a blanket refusal to say no, won't give you follow Rule 35. And that is why we're here. We had to then bring an application. But even as they make the tender, so there are two issues. Firstly, the reason the application was launched, because of the SIU, there must be punitive court scale. But even if the court considers that they gave us a tender, that tender was only in the answering affidavit. And in any event, it was, the tender was not saying to us that you don't have to give a Rule 35 notice. It still refers to Rule 35, meaning we must still specify, and we're going to be given documents that are only relevant in terms of the proceedings. So even the tender is not an appropriate tender in law while we're dealing with reviews. And after filing our heads, referring to all these cases, like what the Constitutional Court says about Rule 35, I expected the SIU to say, look, we're no longer opposed. Let's give you the record and let's get on with it. But still, we're here. And even at this stage, they're still going to argue, of course, that Rule 35 is applicable. And they even told the court that in Chauke, they told the court that they're not bringing a review application. And that is why they were insisting that Rule 35 applies. But they were not telling the court. Even in the heads, they don't say that. So, my lady, given those facts, this is a matter where our application, where LNG must prevail. There must be order to pay to give us the record, Rule 53 record, the record of the proceedings, and then there must be order to pay costs of these proceedings on a tenant plan scale. As the court, please.
Thank you. Mr. Breitenbach.
Thank you, my lady. The relief sought in this matter is an order that my clients, the applicants in the main proceedings, comply with Uniform Rule 53(1)(b) and deliver a record of the decision sought to be reviewed in the main proceedings. And the issue for decision, and the only issue for decision today, is whether Uniform Rule 53 imposes that obligation on the SIU and the MEC, the applicants in the main application. The court has had our heads and is clearly fully acquainted not just with the papers in this interlocutory, but with the founding papers. I do not intend to detain you very long. I wish to make a few basic points in response to what I've heard my learned friend submitting today. The first is that we are dealing here with a self-review, something which the Constitutional Court described in the Buffalo City case in 2019 as a novel but burgeoning species of judicial review. And my learned friend also acknowledged that this is a relatively new development in our law. The second thing is that the proceedings were not brought by the SIU and the MEC in terms of Uniform Rule 53. And they acted in terms of Rule 10 of this tribunal's rules using Form 2. And there is only one respondent, it's LNG. My learned friend submitted to you that the issue that you are seized with today is a novel issue. With respect, it is not a novel issue. There are two cases which are in point and which support the SIU's stance that it standing in the shoes of the department and the MEC representing the department, being the two co-applicants in these self-review proceedings, are not obliged to deliver a record under Uniform Rule 53. The two cases were decided in 2018. First was the Chowke decision, which was decided in January of that year. And the second is Erastyle, which was decided in November of that year. The case from the Eastern Cape, Nelson Mandela Bay Metro, the Erastyle and others. It's in the bundle at 007 with the relevant passages at 104 to 112. I'll take you there in a moment. Before I do that, I'd like to say something briefly about the other side's reliance on the Helen Suzman Foundation dictum in paragraph 26 of that dictum. And may I ask the court just to turn to the Helen Suzman Foundation case. It's in the case lines. The relevant paragraph is paragraph 26, and it's at 007-29. And for your benefit, I'll read it. Justice Madlanga said they dealt with the differences between discovery under Rule 35 and the Rule 53 process. It's helpful to point out that the Rule 53 process differs from normal discovery under Rule 35 of the Uniform Rules of Court. Under Rule 35, documents are discoverable if relevant, and relevance is determined with reference to the pleadings. So under the Rule 35 discovery process, asking for information not relevant to the pleaded case would be a fishing expedition. Rule 53 reviews are different. The rule envisages the grounds of review changing later. So relevance is assessed as it relates to the decision sought to be reviewed, not the case as pleaded in the founding affidavit. Now we know that what's behind that is, as Justice Krichler explained in the Jockey Club and Forbes case, and specifically at 660E to H and 661E to J, which you will find at 000-95 and -96 in the case lines bundle. What's behind that is the unique mechanism created by Uniform Rule 53 for the benefit of an applicant who doesn't know what happened inside the administrative agency whose decision is being sought to be taken on review. What the rule requires in essence is that an application for review be launched, and that once that is done, the decision maker, the officer as it's referred to in Rule 53.1, must deliver the record of the decision taken under review. That record must be made available to the review applicant by the registrar of the court concerned, and the review applicant then has the opportunity, as of right, to amend their notice of motion and to supplement their founding papers. And that is what Justice Madlanga was referring to when he mentioned the rule envisages the grounds of review changing later. So relevance is assessed as it relates to the decision and not the grounds of review. There's a fundamental difference between that situation and a self-review. If a self-review like this is brought by the representatives, two institutional representatives of the decision maker whose decision is taken under review, they have no right to change the grounds of review later. As your ladyship, with respect, correctly pointed out to my learned friend during his address, they must stand and fall by their founding affidavit, having chosen the application form of proceedings. And so, with respect, the cases on which they place such heavy reliance from the Constitutional Court dealing with the benefits of a Rule 53 record are distinguishable. That is not to say that they are not entitled or should not be entitled, provided that they take the appropriate procedural steps to get the information they need to answer. And I'll get back to that in a moment briefly. But I return to the narrow question with which we are faced. Are my clients compelled to produce a Rule 53 record, even though they did not institute these proceedings under that rule? And it's convenient when dealing with the two relevant authorities to start with the Erastyle case. I do so because in that case, the point that your ladyship is called upon to decide today was squarely taken. So Erastyle, it's at 007-103, and I commend to the court, in particular, paragraphs 1, 2, 4, 6, 14, and 16 to 26 of the judgment. As far as the facts are concerned, as Judge Huisen mentions in the first paragraph, that was a trial action. It was an action by the municipality against the defendants in which it sought orders setting aside decisions or conduct of certain of them. They were former office bearers or employees of the plaintiff, and pursuant thereto, repayment of certain sums of money paid to the first defendant, which is Erastyle. The plaintiff's claims arise, according to the judgment, from the appointment by it of the first defendant, Erastyle, as a lead consultant for the development of a marketing strategy in respect of a certain service that it was providing. The court records that pursuant to the appointment, certain sums, well over 5 million rand, were paid to the first defendant. As paragraph 4 records, there are factual allegations quite detailed in the particulars of claim, but in essence, it is alleged that the appointment of the first defendant occurred in breach of the plaintiff's supply chain management policy and not in accordance with, amongst others, Section 217(1) of the Constitution and Section 111 of the Local Government Municipal Finance Act. So your ladyship will appreciate immediately the equivalence between the type of case that one had there and the present matter. A process non-compliant with the applicable, so it was alleged, public sector procurement provisions, resulting in the appointment of someone to supply something to an organ of state. What the municipality sought was review and setting aside of that decision, and then the repayment of money. That is essentially what is being sought in this case, the only difference being that those proceedings were instituted by way of a trial action. The reason for that doesn't appear from the judgment, but I can tell you from the bar what the reason was. It was because the plaintiff anticipated that the facts asserted would be disputed, and that there would accordingly be a need for the court to resolve those disputes of fact. I know that because I signed the plaintiff's particulars of claim in that matter. One of the defendants raised a special plea. The first defendant raised two, but the first of those special pleas referred to in paragraph 6 was to the effect, and I quote, that the plaintiff is obliged, since it seeks a review of its own decisions on the basis of legality, to institute proceedings in terms of Rule 53 and pursuant thereto to file a record. Since it has not done so and has not sought condemnation, therefore, the procedure adopted constitutes an abuse of the process and the summons falls to be set aside. Now, the court dealt with that special plea at paragraphs 14 to 26, and I shan't read to your ladyship anything further from the judgment. The bottom line is the court held that the plaintiff in a self-review like that one was entitled to proceed otherwise than under Uniform Rule 53.1, and having done so was not obliged to deliver a record under Uniform Rule 53. That being a trial action, of course, the plaintiff had to discover once the notice had been delivered under Uniform Rule 35.1. And so that was the normal and natural way in which the respondents in that case could get the information that they needed in order to conduct the trial. That brings me to the Chowkey case. Although decided a few months earlier that year, the Chowkey case was one where, as the court knows, the SIU brought an application which the court held at paragraph 16, despite the SIU's taking up a different attitude, amounted in substance to a review application. The question which then arose was whether the respondent whose decision was sought to be taken on review, the relevant government department, Public Works, as I recall, the 10th respondent, was to oblige to deliver a record. The application was not brought under Uniform Rule 53, and the court held at paragraph 19 that because it wasn't brought under Uniform Rule 53, it would be improper to force the department to deliver a Rule 53 record. What the court added at paragraph 22 is that the proper relief would be an order in terms of Uniform Rule 35.13. So if a respondent in the position of the successful bidder in that case, the first respondent, as I recall, was a consortium of the 2nd to 9th respondents, if they were to be prejudiced by the manner in which the proceedings were brought, namely in that case an application which the court held was in substance a review application, but otherwise under the Rule 53, they could have sought an order under Rule 35.13, which the court went on to make in that matter. Now here, for some inexplicable reason, despite these authorities, the applicant is insisting on a record under Uniform Rule 53.1 and has not applied in the alternative for an order under Rule 35.13, even though my client has consented to such an order being granted. And I must make it clear, that consent is unconditional. We consent to making the tribunal today making such an order. In fact, we would welcome it because it would avoid what we consider to be will ultimately amount to a waste of time if, for instance, the applicants, LNG, the respondent in the main case, were to lose today and to seek to take your ladyship's decision on appeal. My clients are the applicants in the main case. They want the main case to proceed. They do not want the respondent LNG to be in any way prejudiced as to the information that it wishes to which it would be entitled if it had called for discovery and would have at its disposal before it files its answering papers. Hence, in addition to consenting to an order under Uniform Rule 35.13, my clients have tended to make discovery earlier than Rule 35.1 requires. Your ladyship will know, discovery notice is normally exchanged after the close of pleadings, but the court may give leave to deliver such a notice earlier. Implicit in that is, of course, the court will be requiring someone to discover earlier. My clients are quite content for a 35.13 order to be made. All that has to happen, I suppose, formally, is for the LNG to apply for it. They are also tended to make discovery within 20 days of such an order being made. And to make it clear that the other side will be entitled to consider that discovery before having to file their answering affidavit, you'll have seen from our heads of argument that we add that my clients tended to allow them a period of 20 days from that, the date of the discovery, in order to deliver their answering affidavit. The tribunal will be well aware that in applications like this one brought under Rule 10, no time for the delivery of answering papers is specified. Instead, Rule 410.4 says, where the respondent files a notice of opposition, the parties shall exchange answering and replying affidavits within the dates directed by the tribunal president or presiding member at the first case management meeting held in terms of Rule 19. In this case, we did hold such a meeting, and as your ladyship knows, a proposal as to the timetable going forward was made from the SIU and the MEC side, but was opposed because of this in principle issue which has been raised by the LNG. So, my lady, your ladyship has all the tools, legal tools at her disposal to see to it that LNG, should it wish to receive additional information before it delivers its answering affidavit, is able to do so. Your ladyship can, in terms of Tribunal Rule 17 sub 4, read with Uniform Rule 13, direct that the provisions of Rule 35 relating to discovery shall mutatis mutandis apply to the main application. Your ladyship can, in accordance with the tender, direct that my clients are directed to make discovery in terms of Rule 35.2 within 20 days. Your ladyship can also, in line with the further tender made in our heads of argument, afford the respondent a period of 20 days to deliver its answering papers, if any, that's within 20 days of the discovery being made. So this case stands far apart from, amongst others, the Stanton Woodrush case, on which my learned friends rely, where the respondent, the beneficiary of the decision sought to be reviewed, would have been prejudiced by the supine attitude taken by the respondent decision maker in that case. But lady, we have contended, returning to the merits, that where proceedings for self-review are brought under Uniform Rule 53(1)(b), the review applicants are not obliged under that rule to discover the record, as it were, under 53(1)(b), for a number of basic reasons. The first is the obvious one, that the rule itself contemplates and says that the officer performing the administrative functions brought under review is the one which must deliver the record. In other words, a respondent. My clients are not a respondent. Secondly, here, unlike in Stanton Woodrush, the institutional representative of the decision maker, the MEC, hasn't adopted a supine attitude. It's important to just flesh that out slightly. So obviously, the MEC hasn't been supine in that the MEC has joined the SIU in bringing the self-review proceedings. But we accept that that is a step taken adverse to LNG's position, the review applicant. But I've already dealt with the further steps which the MEC has taken through the answering papers filed on both main applicants' behalf by the SIU. The MEC has taken steps to see to it, should the LNG require it, that they can get the documents. I'm referring to the MEC's consent to the granting of an order in terms of Rule 17.4 of the Tribunal Rules, read with 35.13, that the discovery rules shall be applicable to the main application, and of course the further tender to make discovery early, in other words, before the delivery of the answering affidavit. And it's important also to bear in mind that my learned friend's submission that the remedy under Uniform Rule 35 for deficient discovery is simply that my side can't use the documents in the case. That is with respect, is incorrect. That's one of the remedies which is inherent in the rule. But the combination of Uniform Rule 35 sub 3, 35.6, and 35.7 provide for judicial oversight over inadequate discovery. So if my clients were to make discovery as tendered, pursuant to this court declaring the rule to be applicable, and LNG were to consider that the discovery is deficient, they can deliver a notice under Uniform Rule 35.3 calling for further and better discovery. And if what they then get is still unsatisfying to them, they can bring an application ultimately under Uniform Rule 35.7 for an order compelling my clients to make further and better discovery. And if they don't do so, the ultimate sanction is, of course, an order dismissing my client's case against them. So with respect, if one takes a step back and just looks at the architecture of this case, my clients have brought an ordinary application in which they seek judicial review and consequential relief, very similar to what happened in Aerostar, not under Uniform Rule 53. They are consequently not obliged to deliver a Rule 53 record. Hence, the application before you today must be dismissed. They acknowledge the potential unfairness that their choice of procedure will visit on LNG. They have consented to the making of an order under 35.13 read with the Tribunal Rule 17.4 and to discover early, in other words, before the delivery of the answering affidavit. If the discovery is deemed deficient, and we've heard lots from my learned friend about why he considers it will probably be deficient, well, one should wait and see for that, then the mechanisms in the rule can be utilized to compel further and better discovery.
Why should I go that far? That's not what these applicants want. And as I've indicated, there is no right to discovery in application proceedings. This
Yes,
applicant has made it very clear that's not what it wants.
Yes, it's a duck or no.
Why should I grant leave for discovery and open the door for a plethora of interlocutory applications under circumstances where the applicant has made it very clear that's not the relief it wants?
You're undoubtedly entirely within your rights to simply dismiss the application. Of course, the relevance of what I've been saying in relation to my client's attitude aimed to ensure equality of arms and fairness is that for some inexplicable reason, despite everything, well, let me say what that everything is, despite the fact that my client's attitude in this case is supported by two cases which read together are directly on point. This isn't a novel case, it's been dealt with before. Aerostar has dismissed an equivalent exception, and in Chowki, the practical solution that I have addressed you on was advocated, and it's the position my client has adopted from the get-go when the demand was made for a Rule 53 record. So despite my client acting in accordance with authority, despite my clients bending over backwards, frankly, to ensure that there is equality of arms and fairness and that they get the documents that they seek, the other side have the temerity to ask your ladyship to make a punitive costs order against my client. What my client has tendered is highly relevant in that context, as well as the legal basis upon which it has acted. Your ladyship knows from the Secretary of the Judicial Commission of Inquiry into Allegations of State Capture and Zuma case, paragraph 131, which is a 007-123, that punitive costs.
Excuse me, please give me the paragraph again.
It's at paragraph 131 of the Secretary Judicial Commission of Inquiry into Allegations of State Capture and Zuma case. It's quoted in our heads at paragraph 45, and you'll find it at 007-123. The principle is that punitive costs are exceptional and are reserved for instances where a litigant has conducted themselves in, I quote, a clear and indubitably vexatious and reprehensible manner. Or, as the court went on to say, punitive costs orders are indicative of extreme opprobrium. Those are its words. Lady, there's absolutely no question of that here. We are frankly taken aback at the demand for punitive costs. Perhaps the LNG didn't pay close enough attention to the era style case and focused mainly on Chowky. So we don't seek any costs against them. We accept, in other words, that the costs of this case, whichever ways it goes, should be costs in the cause in the main application. That has been the attitude throughout, expressed in the affidavit and in the heads of the argument, and obviously I repeat it here today. So what my clients ask then is that this interlocutory application be dismissed and that the costs of the application be costs in the cause in the main application, lady.
Before I let you go, I must ask you to answer a question that Mr. Motepe asked, and that is, having made the tender, why didn't you simply finish the record?
Because what would then happen is that there would be a potentially unstructured disagreement. The rules of court are, because they might not be satisfied with it. If it's furnished under Rule 53 and it's not efficiently done, then the rules relating to non-compliance, Uniform Rule 30 or 30 capital A could be used, and if necessary, we could come to your lady and have the dispute adjudicated. If it's done under Uniform Rule 35, then, as I've explained, there is a process. A further notice gets given. If that's not complied with to the satisfaction of the party given the notice, then one ultimately comes to court for with an application to compel, and ultimately, if that's not complied with, even an application to dismiss. That's how, in other words, the rules of court provide the structure for the exercise by authority of the court, in other words, judicial supervision of compliance with the discovery process. My client is willing to discover, clients are willing to cover everything that they have to under Uniform Rule 35, which, as I've explained in the heads, will be everything which is relevant to not just to the impugned decision, and we certainly won't, and it's been made clear in the papers, do anything less than what would be required if we had to do a Rule 53 record. But we will do more than that, because there is a very serious allegation of contractual malperformance here, which postdates the decision. In other words, the court knows that the SIU's investigation revealed that all of the surgical gloves which were delivered were cheap, non-sterile gloves rather than the costly sterile gloves which the parties had contracted would be delivered. There's many millions that turn on that. They would get discovery of everything there. So the short answer to your question, my lady, is that kind of informal process, particularly when faced with an applicant adopting this kind of attitude, will lead to an unstructured, in the sense of outside of the rules of court and particularly outside of judicial supervision. That's not in my client's interests. We are applicants. We want the case to move forward, the main case to move forward, because we ultimately want the orders that we are seeking, should we persuade the tribunal to grant them.
Anything further?
Nothing, my lady.
Thank you. Mr. Motepe?
I'm not going to be long, my lady. Perhaps let me start with the last point made by my learned friend. The review application as it stands, about 99% is about documents that relate to what happened after the decision. But that is not why we're here. My learned friend says they will give us even more. But that relates to just an equitable remedy, perhaps. What we are asking for is a record of the decision, not what happened after the decision. That we have and we'll deal with. But it is a record of the decision. And what my little friend says that it will be unstructured if we follow Rule 53, but it is not correct. If they simply give us all the documents, the record of the decision, then we have the record of decision. We see exactly how this decision before it was taken? What processes were followed? How the PPEs were identified? All those things, we see that. But that is what we're asking for. It is clear if you order Rule 35, again, they're going to burden us with documents of what happened after. That's not what we're asking for. But again, Rule 35, and I don't know how I must emphasize this, the Constitutional Court says it deals with documents that are relevant to the pleaded case. That's what HSF says. It says so under the Rule 35 discovery process, asking for information not relevant to the pleaded case would be a fishing expedition. So they are entitled, if we ask for something, to come and say, no, but that's not relevant to our pleaded case. HSF says, so relevance is assessed as it relates to the decision sought to be reviewed, not the case creating the funding affidavit. So there's a clear distinction between Rule 53 and Rule 35. The cases that you are referred to, none of them is on point. We have already demonstrated that childcare is a contractual matter. The Aristotle case you are being referred to, it was an action. And the special plea was that you should not have brought an action. You should have brought an application in terms of a review. This will be the first case where the court will say, in a review application brought, a party against whom this, the adverse decision, of course, being reviewed affects my client. To be the first case where the court will say, despite the fact that we don't know what happened behind the scenes, we're not entitled to the record. This will be the first decision. And for that reason, if the SIU is going to prevail, we'll of course request reasons before we decide what further step we take, because this is a very important case for us, and I would dare say not only for us but also for the SIU. So the decisions that we're being referred to, they're all irrelevant. The argument that the applicants in the main application have not taken a supine attitude is wrong. Yes, they have brought the review application, but insofar as the record, they've taken a supine attitude. And where Jockey Club says the applicant is not shackled by Rule 53, these applicants who are decision makers, they are shackled to produce the record. They may not be shackled to bring an application under Rule 53 in a sense of the notice of motion as we know it, but they are shackled to produce the record. It cannot be that in our constitutional dispensation, a decision maker says, I go to court, I decide what I'm going to give you, and if you want more, use Rule 35. It cannot be. It can be. In any event, we've made our submissions, and we say our application, the LNG should prevail. The SIU is wrong, and not only for this case, even going forward, the SIU needs to know that it must give the other side the record. It is only a fair thing to do, not discovery. We're not talking about that. So, my lady, those are our submissions. We persist with our application, and with a punitive court order, we still persist with that, because none of the cases referred to here are of any relevance to this case. But those are our submissions, my lady.
Thank you very much for your assistance. Judgment is reserved.
As a please.
The proceeding sergeant.
As a please.